Good afternoon. Welcome to the third webinar in our four-part webinar series in which we look at key issues in the regulatory landscape of investigations in corporate crime. Today we'll be looking at dawn raids. The previous webinars in the series looked at regulatory inspections and investigations and private prosecutions. Recordings of these webinars can be found by following the link shown on screen now. Before we start the webinar, just a few housekeeping points. To minimize background noise, we've placed you all on mute. If you would like to ask any questions, please do so using the webinar chat function, and we'll pick these up at the end. Your speakers today are Aista Slesevichute and me, Zeno Frediani. Aista and I work in the Regulation and Markets team and regularly advise clients on competition law and investigations. So in today's webinar, we'll look at the general features of a dawn raid, and we'll then focus on a particular example. For our example, we'll look at the powers that the Competition and Markets Authority and the European Commission have for dawn raids in competition law cases. We'll then look at the penalties for obstructing a dawn raid, and finish with some practical tips and advice to keep in mind before, during, and after a raid. We hope this will be helpful to help you think about potential risks and the ways in which these can be controlled and mitigated. Let's start with a brief look at what we mean by dawn raids. These are unannounced investigations carried out by officials into suspected illegal activity. Various investigatory bodies have the power to carry out dawn raids, and they depend on the type of illegal activity which is suspected, and each body has different powers. For example, the CMA and the Commission can raid businesses suspected of anti-competitive practices. This is going to be the focus of our case study today. You'll see on the slide some examples of the bodies that have these powers. That you can see that they cover a pretty wide spectrum of activity which could potentially result in a dawn raid. Most high-profile investigations will involve a dawn raid at some stage. A recent example that you'll all have heard of involved a raid on the 7th of October. There you had 50 prosecutors and other investigators raiding the Wolfsburg offices of Volkswagen and the residences of a number of its employees. The prosecutors were looking for evidence of who was aware that the company had manipulated their emission software in its vehicles. The main thing to remember about a dawn raid is that it's unannounced. So what's really important with this is preparation. It's really crucial that all businesses are prepared and able to act should the investigators turn up at your office one morning. I'll now hand you over to my colleague, Aista, who will discuss our example dawn raid.
Good afternoon. Thank you, Zeno. So I will be looking at an example of a competition law dawn raid, and such dawn raid would look at cartels, abuse of dominant position, and the new UK cartel offence. It's usually carried out by the Competition and Market Authority. If there is an EU angle to an investigation, they may be joined by the European Commission, and in the UK, the sector regulators such as Ofgem, Ofwat, Ofcom, FCH, name but a few, can also investigate competition law breaches. Just a few weeks ago, Ofgem announced that it is investigating 2 or more companies for sharing information on the commission rates they charge the energy suppliers. So broad powers for competition infringement. The Table 7 shows power of entry by CMA and the European Commission, and authorities have broad powers of entry but cannot go on fishing expeditions. That's the important point. They must have reasonable grounds to suspect an infringement. The powers differ depending on whether an authority has a warrant, and the CMA may apply to the court to obtain such warrants if there are reasonable grounds for suspecting that there are documents on the premises relevant to the investigation. And you will see that if the CMA obtains such warrants, the powers of entry are actually quite wide. They can enter business as well as private premises, and this includes cars as well. With the warrant, they can even use force and be accompanied by police force. Upon entry, it is important to check the scope of the investigation, and the authorities should provide a document, whether it be a decision or a warrant, that should detail the scope of the investigation, and this will affect, obviously, the documents that they can or cannot obtain. There can be just the one business segment that is under investigation, for example. Authorities may also ask to access personal emails, and if there is a suspicion that a private email is used for business. And they are usually accompanied with IT forensics experts, as I will explain in later. So I will now turn to the powers of search. So this is the following two slides will examine what happens when the authorities actually enter the premises. The search and questioning can be very stressful for the employees across all levels, but it is very important that the staff are trained and there is a firm-wide policy in place, as Zeno will explain later. The authorities can search paper and electronic documents, and they can take copies of such documents. To search electronic documents, the investigators will ask to access IT servers, so it is important that the IT staff are also well informed about what is going on. It is noteworthy that the CMA has newly appointed role of Director for Digital Forensics and Intelligence, and similarly the EU Commission also has a trained team of specially trained IT investigators. The slides show the different powers between CMA and the Commission, with and without warrants, and the important point to note is that the authorities, even with the warrant, do not have the power to seize and sift documents. The authorities cannot collect any documents they want. They will only collect documents that fall within the scope of the investigation. In fact, the authorities would not even want to collect the documents that are not relevant because they need to account for them on the file, and they need to then later produce a non-confidential version. And here I would like to point out that documents do carry confidentiality, and all the authorities are under strict rules to protect the confidentiality of the documents they collect. That is very important. And Zeno will also later cover the importance of the legally privileged documents. The powers of questioning, the authorities can ask for an explanation regarding documents and the facts on the spot. So they can approach any member of the staff, and they can ask to produce a document and can ask a general question regarding that document. It is advised that a note should be taken on any such questions by the investigator. In civil investigation interviews, the interviews can only be conducted with consent of the interviewee. I will address criminal investigations in the next slide. However, it is crucial that employees are advised accurately when they are obliged to reveal the information and when they should maintain silence. Here again, training is very important. So this covers the civil investigation and the powers of questioning in such investigation. There are also powers in terms of criminal investigation, that's namely a criminal cartel. And here the liability for individuals is quite significant, up to 5 years of imprisonment and a significant fine. Therefore, it is very crucial to obtain legal advice if the criminal investigation is indeed carried out. The CMA may caution the staff. The CMA may question staff under caution. That is very important. It has also been granted very wide powers of surveillance. So even before the investigation takes place, they do exercise those powers. And I will now briefly discuss the penalties for failure to submit to investigation. So what happens if the investigators come and for some reason staff turn them down, or there are other practices. So serious penalties may apply for obstructing an investigation. And this includes obstructing an officer carrying out an investigation, destroying or concealing falsifying documents, or providing false or misleading information. Obviously, tipping off your competitors is also not advisable in a similar situation. Calling other offices is also should be done only with legal advice, and everything can lead to significant penalties in this regard. CMA and Commission have different powers to impose penalties, as detailed in the slide. They can impose a fixed penalty of up to £30,000, the CMA, and they can also have a periodic penalty fine of £15,000 per day. There is also criminal liability for individuals who obstruct an investigation, so that is very serious indeed. The penalties by the European Commission may be imposed for non-compliance as well, and that is up to 1% of an annual global turnover of the company, and that may add up to a very significant fine indeed. However, the European Commission has no power to impose criminal sanctions. I will now look at some of the examples for obstructing an investigation where the European Commission actually imposed a significant fine. The CMA is the newly appointed authority, and I will address the guidance issued by the CMA in regards to setting penalties. The European Commission has issued a significant fine for destruction of documents. It is well established that shredding practices and destruction of evidence is not going to be taken lightly by the authorities during the dawn raid. So all the staff on the premises should be made aware of this at the beginning of the dawn raid, if possible, because as Zena will explain later, members of the staff may feel they are helping the business, whereas they really not. As you will see, a fine against Sony was increased by 30% because documents were destroyed during a dawn raid. Similarly, because the authorities have the power to seal the premises at the end of day one of the investigation, if such seal is broken, the fines imposed are very significant. In the past, the European Commission fined E.ON 38 million euros after investigators discovered that a seal had been tampered with. Now, this case went all the way to the highest court of the European Union, and the fine was upheld, even though E.ON very fiercely argued that the seal was tampered actually as a result of the cleaning agent that was used by the cleaning staff, and there was no evidence whatsoever that the documents in the room were by any way tampered with. So there is no need to show that the effect of breaking the seal, the very fact that the seal was broken, is enough to stay in such a heavy fine. Similarly, a French water company was fined 8 million for a breach of seal more recently. Failure to block email accounts, as requested by the Commission, will also be fined, and a company was fined 2.5 million for failure to block email accounts, and it was also found that some emails were redirected. These are just few examples of a number of cases where obviously huge penalties were given. The CMA guidance issued on how they will deal with the investigation show that they will decide on a case-by-case basis on the level of the fine, but obviously up to a statutory maximum that was detailed in the slide before. The CMA may consider the following when setting the fines. So the list is not exhaustive. They will look at the nature and the gravity of the failure to comply, a reasonable excuse, and steps taken to mitigate the failure to comply, past failures of the company, administrative and financial resources available to the company to comply with the investigation. However, it is similarly, as the position with the broken seal, a failure to comply may still result in a penalty, even if there is no actual impact on the investigation. That is it from me, and Zeno will now turn to the practical tips and advice for preparing and dealing with the dawn raid.
Okay. Thank you, Aisa. So we've seen the powers that investigators have, and you can see the penalties for obstructing a dawn raid are pretty severe. So the commercial implications of financial exposure resulting from dawn raids are obviously significant. So what should you be doing before a raid? Planning and preparation are probably the most effective tools to minimize the potential impact. It's really important to have a clear and well-understood dawn raid strategy in place. Regulators and other stakeholders are increasingly looking at corporate governance, so it's essential that a company's senior management feed into the strategy. I mean, after all, they're going to be the ones that are judged on how the company copes with any investigation. The strategy and the general approach to dawn raids is likely to depend on the situations of each company. So, for example, if you're in a regulated industry or if you've got operations across multiple jurisdictions. But there's a couple of steps that everyone should really consider. The first step is to establish a policy and a protocol for dawn raids. Now, this should include provision for training of all staff, and this means training not just about compliance generally, but also training about dawn raids and investigations themselves. During a raid, members of staff are likely to be at the front line. It's important to make sure that your reception, your secretarial, your IT services, as Aisha has mentioned, that they all have set guidance that are relevant to their roles. For example, your receptionists are going to be the first port of call when the dawn raid investigators arrive. They should be specifically briefed on who to contact. Communication delays between receptionists and senior staff in the past have greatly complicated dawn raids and can result in very costly delays. The next thing is to plan your communication strategy. It's obviously essential to have a plan in relation to your media and press, but also your communication plan has to cover all of your stakeholders. If you think about how your employees are going to react when they see investigators going through their email accounts or through their drawers, they're likely to have concerns about the impact of the investigation on their job security and the work environment and things like that. So regular communications are really important to keep people focused on the job because, of course, while the investigation is happening, the company still has to keep working. Investor relations are also really important. Listed companies should have to consider whether the stock market rules require them to make the fact that the raid has happened public. You'll also have to decide whether and how to ensure key institutional investors and private investors are aware of the appropriate facts. So as well as thinking about individual stakeholders or groups of stakeholders, your communication plan should look at the timing of your communications and your announcements. As I mentioned, it's important not to tip off any competitors. That won't be received well. Also, if you're a listed company, you have to think very carefully about how you time your internal and your external announcements. You have to think about how the information and when the information gets to the market. So you've got all your plans, your training, your policies and protocols in place. A good way to test them is with a mock dawn raid. This can be one of the most useful tools for preparing for a dawn raid, and it's something, obviously, that we're happy to help our clients with. The idea is that a designated legal team will turn up at your offices, posing as the Commission or another one of the investigatory bodies. Only the most senior staff will know that it's a mock, and this is the best way of ensuring that the systems and procedures that you've put in place will actually run smoothly if a real investigator turns up. The final step in your preparation is to retain a designated external legal team. Dawn raids happen quickly, so it's important to know who to call when they happen. When you're thinking about your external teams, you should really think about where all your key locations are and make sure that they're covered. For example, you might have a head office in London, but you've got large operations in Edinburgh or Manchester. You really should consider appointing local teams for those. Also, if you've got operations abroad, you want to make sure that those are also covered. So you've done all your planning, your training, you've carried out your mocks. What happens when you have a real raid? The obvious answer is obviously you follow the protocol that you've set up. You know, lots of guidance that you hear about dawn raid tells you to ask the investigators to wait for your external legal team to arrive. You should definitely do this, but you should also be prepared for the fact that the investigators may not wait. You know, a half-an-hour taxi journey is likely to be reasonable. Asking them to wait for a flight from a different city probably isn't. You should also take into account the fact that investigators are unlikely to wait for external legal advisors if you have internal in-house lawyers available. So you should have a few practical things in mind. The first thing to do is to clarify the scope of the investigation. I used to mention, you know, no, they're not allowed to just come fishing for documents. The investigators will have some sort of document with them that sets out the scope of the investigation. This will be the warrant or a commission decision. They can't simply just come and look for something incriminating. We've seen that the penalties for obstructing an investigation are very severe, so it's important to cooperate with the officials. But what is it that we mean by cooperate? So, you know, be responsive, be polite. It also means absolutely no document shredding, no document destruction, no IT obstructions. This is probably going to be an obvious point for senior staff and in-house lawyers, but it's important that junior staff are aware of this as well. They know not to destroy documents even if they think they're doing it to protect the business. You should also keep a clear and accurate record of the raid. This will include things like keeping a copy, or at the very least a record of all the documents that have been collected, keep a written record of any of the interviews that have been carried out by the officials, and mark all documents that have been collected as confidential. As Aisha mentioned, it's important that, you know, they do treat these documents as confidential. You should also consider whether the documents are protected by legal privilege. Now, this is a term which applies to certain documents and correspondence which is prepared by your legal advisors. Your legal team will probably be able to advise you which documents carry this protection, because it can get quite complicated. And documents that carry legal privilege should be placed in a separate envelope. You should also remember that the investigators also have to obey the law. So being cooperative does not mean that you should give them all the information that they're not, even if they're not required, if you're not required to give it to them. And also keep in mind not to sign any documents without first getting legal advice. Let's move now on to the aftermath of the raid. This is really where your communication plan comes into its own. The first thing to do is debrief the team that was dealing with the raid. Senior management should also meet to ensure that everyone is fully aware of what happened, and you want to be able to present a consistent front going forward. Divisions at board or senior management level can be a real risk in these situations. Then communications to employees, investors, customers, other stakeholders should follow that. As we said earlier, it's important to think carefully about timing, content of communications. As with the pre-raid strategy that you put in place, you should also think about getting a post-raid strategy in place as quickly as possible. You should be ready for subsequent investigations and litigation. Depending on the type of raid that you were exposed to, you can think about things, for example, you might want to consider making a leniency application for breaches of competition law. It's also likely that the investigating authority will require follow-up information. They're going to make requests for information and things like that, so you should be prepared for these. Remember that dawn raids tend to be the start of long, drawn-out, sometimes painful processes, so you should consider putting a dedicated team together within the business to deal with the investigation and any follow-on litigation. You should also review all of the documents and the evidence that was collected by the investigators. So to recap, dawn raids are likely to have a significant impact on any business that experiences them. Now, because they are unannounced, the best way to deal with them is to have a good policy and a good plan in place. Whatever you do, don't leave them to the last minute, because you never know when someone will turn up. That concludes today's webinar. What we're going to do now is take some questions. As I mentioned at the beginning, questions can be submitted by typing in the chat box. While you're doing that, I would just quickly mention the final webinar in the series is due to take place on Thursday, 26 November. Our colleagues will explore what companies do to manage a crisis effectively, focusing on preparations they can take in advance how they should react to a crisis as it unfolds, and what the critical factors are that they should seek to control. There are also a number of other webinar series that Shepherd and Wedderburn run. These cover commercial contracts, IP litigation, and we also have a property dispute series. If you want to find out more about these, the link on our webpage is on the screen. I'd like to remind you that the webinar counts towards your CPD requirements for the Law Societies of England and Wales and Scotland as well. So we've had a question. I'll read it out for everyone's benefit. Is legal privilege different in different countries? In short, the answer is yes. There are quite different approaches to privilege in different jurisdictions. If you take England and Wales, for example, communications with your in-house lawyers are privileged, well, can be privileged if they're providing advice in their professional capacity as lawyers. But communications with your in-house lawyers are not treated as privileged for European Commission competition proceedings. In those proceedings as well, you should take into account the fact that communications with external non-EEA qualified lawyers are also not privileged for EC competition proceedings. Another example, you've got Germany, where there is virtually no concept to legal privilege in civil proceedings because they have very limited civil disclosure. So you can imagine from that a situation where you've got a privileged document under English law that is disclosable in foreign proceedings. For example, the EU Commission might decide to use it as evidence in its decision. We touched on, when you're preparing for your investigation, the importance of preparing for different, your operations in different jurisdictions. So in that situation, you should really think about privilege in each location as well. It's worth instructing local lawyers at the outset to discuss privilege and how you're going to deal with documents in those jurisdictions. Don't forget that those considerations should feed into your document retention policies and your locations as well. And in some instances, if you're taking legal advice, you should consider whether it's appropriate for your internal legal counsel to consult external legals at the external offices rather than doing it in-house. So you don't have any, you just never end up with any of the documents.
This is for the purposes of the EU Commission.
Yeah, sorry, for the purpose of the EU Commission investigation.
Exactly,
yeah.
And that's common practice.
Yeah, yeah. So that seems to be all the questions for today. If you have any further questions, please get in touch with us, whether it's Dawn Raids or any other investigations in general. You've got the details of our Dawn Raid response team on the screen, so we'd be happy to speak to anyone. Thank you very much.
Thank you.